Hello again. The British legal system, or to be more precise, the English legal system, has given the world many important principles which were, until 25 years ago, regarded universally as being jewels in the crown of liberal jurisprudence. I wish to look at two of those principles this morning, one of which has already been scrapped and the other will almost certainly soon be going the same way. The abolition of both is, curiously enough, tied up with the immigration to this country by people from South Asia and the Caribbean. The first is what is known in Europe as autrefois acquit, and in the United States it's more generally known as double jeopardy. The second is the right to a trial by jury. The Norman conquest of England in 1066 meant that various new legal concepts were brought to this country. Among these was one which is still known by the Norman French term of autrefois acquit, which means already acquitted. It very simply means that if once you've been tried and acquitted of a crime, even murder, and if you've been acquitted, you can never be tried again for that same offence. This is the law bending over backward to be fair to defendants, and it was acknowledged in this country from 1066 until 2003 that this is a most precious and valuable principle, which shows how fair the British legal system is. In 1993, a young black man was murdered by some white men. Some of them were then tried for the murder of Stephen Lawrence and acquitted, which should, according to 1,000 years of British legal practice, have been the end of the matter. However, because the police handling of the case was thought to be inept, a commission was set up to examine the circumstances surrounding both the murder and the subsequent police investigation. When the Macpherson report was published in 1999, the police in London were denounced as being institutionally racist. The whole affair had become focused on ethnicity and race, a direct consequence of the large-scale immigration to Britain which began after the end of the Second World War. As a result, there has been a great deal of agonising over supposed racism, and the Lawrence case was seen as symbolic. The picture of the young man in question becoming almost an icon, which led to his mother being elevated to the peerage. The Macpherson report, keen to see those involved in the crime should still be punished, despite having been acquitted by a court, recommended that the principle of double jeopardy be abandoned in cases of murder. This was duly done in the 2003 Criminal Justice Act, and the acquitted men rearrested and then convicted. In this way, 1,000 years of British legal practice was thrown away due to immigration. More recently, the government in Scotland is trying to abandon jury trials for one of the most serious crimes, rape. This idea is being pushed forward by the First Minister of Scotland, Judicial. The Victims, Witnesses and Justice Reform Scotland Bill would do away with the need for juries in rape trials, something of course enshrined in Magna Carta, and allow judges to decide on the innocence or guilt of an accused man without bothering with a jury. It is an atrocious idea, which if it were to be adopted would soon spread to other types of offence, because it would make everything so much easier and cheaper. It would streamline and speed up the whole process of convicting people. Judicial, who is dead keen on this idea and is pushing for it to be adopted, wants to be able to point to something which his government has actually done for women. It's a political idea. There's been a lot of criticism of his enthusiasm for trans ideas, criticism from many women, and he wants to show that he hasn't forgotten women and that he's on women's side. His family background is a country which doesn't have jury trials. Pakistan regards them as being old-fashioned and the legacy of colonialism. Since Scotland's First Minister is still very bound up with his Pakistani identity, He took the oath as a member of the Scottish Parliament in Urdu and appears at events at the Scottish Parliament in Pakistani national costume. It is perhaps not surprising that he should be keen to see juries abandoned in Britain too. The influence of immigration from the Indian subcontinent is thus revealed. Humza Yosef's enthusiasm for this idea is at least as much due to his heritage as it is any legal justification for the notion. The effects of immigration in Britain are not always limited to those which are most obvious or frequently mentioned, but changes in the law, particularly scrapping very old principles, are at least as significant as anything else that one can think of in association with immigration.